record on this computer. Okay, I start recording.
Yes.
Okay, so I start.
Mm-hmm.
Good morning.
Wait a second, Federica.
yeah.
I need to launch it. Wait a second.
Okay, sorry.
No, don't worry. Don't worry. Good morning to the guests that join us. Good morning to Sarah and to Federica. We today are gathering online to conduct the pre-submission, pre-PhD thesis submission, pre-evaluation. We will have Federica Muscaritoli presenting her findings so far. Federica is a couple months before submitting her thesis, and for our external evaluator, we have a Professor Sarah Schoenmaekers joining us. Professor Schoenmaker is an endowed professor of EU law at the Open University and professor of construction law at the Hassel University. She also is associate professor at Maastricht University. So thank you so much, Professor Schoenmaekers, for joining us and for taking on this task. We're very grateful. How the event today would be proceeding. First, we'll give floor to Federica for a maximum of 40 minutes presenting her thesis. She will present a general overview of the thesis, and then she focused more specifically on one of her chapters. And Professor Schoenmaekers indicated she would want to hear more about. After that is conducted, Professor Schoenmaekers would take her time to provide feedback. That feedback will most presumably again take a more extended time in which various parts of the thesis will be commented on. Then we will see there might be some points of questions and discussions and answers from Federica. In the end, we also will open the floor for any comments or questions from the floor. So from our guests that also joined that would like to maybe ask questions. What is important also to underline here is that the purpose of this event is for Federica to receive a constructive feedback. Therefore, there is a presumption that there will be points made about how the thesis can be improved further. So the purpose is to ensure that Federica leaves today with some ideas of what she can further improve before the submission of the thesis. I probably should have said that at the beginning, but just to conclude, my name is Marta Andhov. I'm Associate Professor at our Faculty of Law. I'm also Federica's supervisor. And in this capacity, today I'll be chairing the session. So I think without further ado, I will give the floor to Federica to start presenting.
Thank you, Marta, for the presentation. I activate just my timer, so I keep track. And good morning, everyone who decided to attend this evaluation seminar, but most of all to Sarah, who I have the pleasure to be assessed by. As already said, I'm Federica Muscaritoli. I'm a PhD fellow here at the University of Copenhagen and ESR within the SAPIENS network. My thesis is preliminarily titled Public Procurement as a Tool for Climate Change Mitigation. Okay. How do I do this? Okay. A bit about myself. I hold a bachelor's degree in political sciences and international relationship from Rome, University La Sapienza, with a minor in law. During my bachelor degree, I was an Erasmus student at Carlos III University of Madrid. After having defended my bachelor's thesis on the control limiti theory on EU constitutional law, I moved to Turin, where I had a master's degree. LLM depends. The Italian system is a bit controversial in that. In European Legal Studies at the University of Turin. And then I had an Erasmus experience at Sciences Po, Paris. I was teaching assistant in food law with Professor Roberto Caranta. And I defended a master thesis on the topic of sustainable food procurement with a case study on the University Pompeu Fabra of Barcelona. And currently I am a PhD fellow at the University of Copenhagen. Sorry, it takes a while to change. Okay. So the agenda for today is that before I will introduce you to the thesis structure and the relevance of my topic, why this thesis is useful and why this is the right moment to investigate on this topic. Then we will go about the thesis scope, more specifically the legal thesis scope. We will you will be presented with the research questions guiding my work, and then we will go to the main findings of 2 chapters specifically of my thesis, and the interpretation I give of 2 specific articles in light of the Directive 2014-24, and then we will conclude with the final reflections and the conclusions, and also an overview of the chapters that have already been written and what is still missing, and I need to focus on in these remaining months. The thesis is divided in 3 main sections. There is a section on the introduction and foundations of the topic. There is a first chapter within it about the aim, the scope, and the methodology utilized for this work. There is a second chapter on the main elements of a public procurement procedure. This chapter focuses almost exclusively on the main principles governing the procedure. I would like to specify that the principle governing the procedures are like in this, for the scope of this chapter, I refer to the older principles and not to the sustainability principle and the principle of competition. Then we have a third chapter on the historical evolution of green public procurement law, how basically the legislation evolved along the years, and how do we get to the stage where we are now. Section 2 is more specifically devoted to the moving frontiers of low emissions public procurement. That's how we defined in a book chapter with my supervisor the public procurement aimed at the reduction of emissions. And this section is the most explorative one, because in chapter 4 we define low emissions public procurement, and basically we analyze the interplay between the European climate law and the Directive 2014-24 that regulates public procurement. We have in chapter 5 the interaction between climate change mitigation in EU primary law with Directive 2014-24, and the same will happen in chapter 6, but in relation to secondary legislation, so the adopted or proposed directives and regulations. In section 3, we have conclusions and recommendations. So the final chapter or chapters depends on the length and the other findings provided within like the whole work. Will provide a summary of the conclusions, but also recommendations for the futures and what the researchers, me in particular, foresee for the future of public procurement law in the European Union. So today, more specifically, we focus on 3 chapters of this thesis. The first one about the aim, the scope, and the methodology. The 5th one on the interaction between climate change mitigation in EU primary law and in EU secondary law, but just an overview. So for those in the audience who might be a bit unfamiliar with the public procurement, it is important here to stress that public procurement law at the European Union level is a system of provisions and of principles regulating what happens before the award of the contract. What happens after the award of the contract is called contract performance and is not covered by Directive 2014-24, that is specifically one of the directives within the package of public procurement, which regulates, is to say, the award of supply, works and services within the European Union when the value of those purchases is above a certain threshold. So we focus today on this bigger part of the screen, which is the public procurement procedure, where basically is composed by several phases. At the beginning, the contracting authority, may that be the state, may that be a region, a local authority, a municipality, defines the needs and make a draft of the contract notice. The needs are more or well defined. Then there is the publication of the contract notice with all the specifications provided by the contracting authority. And then there is the phase of the procedure where the contracting authority pass on to exclude candidates which it deemed unreliable, the selection criteria, which basically are positive kind of criteria to scheme away some candidates who are not like necessarily good for this specific procedure. And then there is the award criteria. The award criteria is the phase where on additional elements, the contracting authority awards additional points for characteristics which are important to the contracting authority but not necessary. The relevance of the topic in the current legal landscape is due to the fact that, especially for the climate mitigation side, the European Union and all the member states are now bound by the objective of reaching emissions reductions of 50% by 2030, and the Union will become climate neutral by 2050. And it's not really clear from the European climate law how this objective is going to be achieved. It is said in climate governance that the EU climate law represents a sort of, the obligations contained in EU climate law are kind of called climate policy integration obligations, because although the law is defining more substantive in a more substantive way than procedural, it is said that the only way to achieve these objectives is actually to for these objectives to penetrate all fields of law within the European Union. Otherwise, we will never reach them. The second main element for the relevance of this thesis is that we are witnessing actually for a few years now, starting from the adoption of the European Green Deal, an increased adoption in environmental laws and climate change mitigation laws. And what is peculiar about all this legislation that have been adopted proposed by the Commission or adopted by the whole European legislative is that in many of them there are new obligations for public procurement. So basically, if before public procurement was exclusively regulated by Directive 2014-24 and with regard to environmental aspects, not in a mandatory way, now we are witnessing an increased number of obligations inserted in legislations other than Directive 2014-24 and also in a mandatory way. These kind of requirements, obligations, have many different natures. They can be defined in terms of targets for the contracting authority. So, for example, reach a certain reduction of energy use, or to achieve a certain use of energy from renewable resources for public buildings. It can be defined in terms of exclusion grounds, like in the case of the deforestation regulation or the Green Claims Directive, or in terms of what to buy or not, what to not buy for the Clean Vehicles Directives or the regulations on batteries and waste of batteries. So the thesis scope in terms of legal framework is that my thesis focuses exclusively on the EU law legal system. In terms of public procurement, as I already mentioned before, the only directive of the public procurement package taken into account is Directive 2014-24 on the public procurement of goods, goods, works, and services. Sorry for the mistake. But other directives from the same package are excluded. On the climate change mitigation side, we have a twofold analysis. We focus on the EU Treaties environmental principles, in particular the environmental integration principles, which is stated in Article 11 on the Treaty on the Functioning of the European Union, and also other very important principles regulating the whole environmental and climate change mitigation law in the EU, and expressed in Article 91 TFEU, which are the polluter pays principles, the precautionary principle, the preventive action principle, and the principle of rectifying damage at source. And this for what regards the primary law sources. For what concern EU climate and environmental law in secondary law sources, we have here a few examples. For example, the batteries and waste of batteries regulations, the Clean Vehicles Directive, or the Energy Efficiency Directive. The way these theses go about all these sources is basically to understand what is the interaction within them. The environmental principles will be first analyzed in terms of their scope, ratione personae, and ratione materiae, and we will see whether they apply to, and to what extent, to Directive 2014-24. This work has already been started only with regards to Article 18 TFEUA by scholars previously, but for the other principles, there is no literature on how these principles, whether and how this principle apply to Directive 2014-24. For what concern the secondary law sources, well, we started, some scholars already started to understand the implications of these secondary law sources on Directive 2014-24. But the aim of this thesis is to provide not only a mapping exercise, but a complete overview of how these new rules contained within the regulations or directive, or the proposed regulations of directive, interact with Directive 2014-24. And why this is important is because some of the rules, and I can mention as an example the EU deforestation regulations concerning public procurement and contained in EU climate or environmental law, do not necessarily fit with the public procurement legal regime established in the European Union. So it is important to understand how to properly interpret these new rules in such a way that can fit with the rules already established in Directive 2014-24. Indeed, like the way I will go about this analysis is through a dogmatic legal method, so which is basically aimed at understanding how not how the law should be, which is mainly a de lege ferenda approach, but a de lege lata, what we can do with the laws that we have, and how can we interpret in a way that they are coherent, they function all together, basically. So the research questions that guide my my work are four, but there is an overarching research questions which asks, how does the EU public procurement law address climate change mitigation? And these bigger questions is divided into three smaller ones. So how did the evolution of EU public procurement law lead to the current legal landscape? Then we will go about how the EU treaties address climate change and how do they impact EU public procurement law, and the same for adopted and proposed regulations and directives. How do they impact EU public procurement law? So, as we said before, the EU public procurement procedure is regulated by several rules. Some of them are principles, which have been extensively analyzed and which derive from EU case law. But there are two principles that created in the last few years few interpretative doubts. One is the principle of competition, which is outside the scope of this presentation, and one is the principle of sustainability. All these principles are contained in Article 18 of Directive 2014-24, and in particular, the sustainability principle is contained in the paragraph 2 of the same article. It has been reiterated recently by the court that the Article 18.2 is a principle to the same extent as all the others are, but it deserved special attentions because its formulation is a bit complex compared to the other principles. Article 18.2 states that member states shall take appropriate measures to ensure that in the performance of public contracts, economic operators comply with applicable obligation in the fields of environmental, social, and labor law, established by union law, national law, collective agreements, or by the international environmental, social, and labor law provisions listed in Annex 10. What is important about this article is that, first of all, is it addressed to member states, while the subject to Directive 2014-24 are not exclusively member states, but also contracting authorities, whatever is their level of administration. Then the second peculiar aspect about Article 18.2 is that despite being a principle, so it is presumed that it has a wide application, and more specifically application to the precise scope of the directive, which is, as we said before, the public procurement procedure and not the execution, not the performance, is exactly this. The Article 18.2 applies to the performance of public contracts. The provision then go on to stress that member states shall take appropriate measures to ensure that economic operators comply with applicable obligations without defining what applicable obligations are. And for the scope of this analysis, and for you to better understand what I'm going to explain in the following slide, is important to know that the only aspects of these provisions I'm going to focus on is the environmental obligations and established by union law. The rest is outside the scope of this presentation and the thesis itself. In terms of Article 18.2 Ragione Persone, so who does this article apply to? It is wondered whether it is applied to member states as democratic institutions or in their role as purchasers. It is also wondered whether member states is a general term to refer to all kinds of contracting authorities, and this is a suggestion that comes from recital 37 of the directive, which repeats the same obligation contained in Article 18.2, but by also referring to contracting authorities. And then the third doubt concerned whether Article 18.2 legal significance is to be found in one of the several provisions contained in Directive 2014-24 that makes a reference to it. We will see them in detail later. In terms of ratione materiae, we need to understand what are the applicable obligations and also the doubt that we were dealing with before. Performance or executions, public procurement procedure, yes or no. So the first point is that if it is a principle, it should apply to both the performance or execution, which they are synonym, and the process, or just to the process, or just to the performance. Well, also in this case, the recitals create some doubts, because recital 40 refers to the procedure. Not to the performance or the executions like Article 18.2 does. And principles usually have a wide applications. And then what are applicable obligations? They are not really defined or listed. What is sure is that even if the obligation is lying on member states, the provisions creates a double kind of obligations, because there is an obligation on member states to ensure, and one on economic operators, which are the subjects with which the contracting authority creates a contract with and that participate before the contract is awarded to the public procurement procedure. These subjects need to comply with environmental, social, and labor law established in international, European, and national law. So, applicable obligations on economic operators cannot be those mandatory sustainability requirements we were mentioning before at the beginning of this presentation, because those mandatory sustainability requirements that would be also analyzed within the scope of this thesis do not apply to economic operators per se, but to contracting authorities during the procedure. What tells us that the applicable obligations must be interpreted in a broad way is the example of the Posting of Workers directives, which is basically an example of European secondary legislation in the field of social obligation, which applied to a public procurement procedure and execution of a public procurement procedure, without that containing a direct reference to Directive 2014-24 or to public procurement in general. So when we say applicable obligation, it must be interpreted in an extensive, in a broad manner, as to include all those legislation which can have a cross application to economic operators during the procedure or the performance of a contract. But as we said, there are several provisions within the directive that makes a reference to Article 18.2, and it has been suggested that those provisions can clarify what is the specific application, specific interpretation that we could make of Article 18.2. First of all, this table, don't get scared by it, is aimed at explaining, summarizing all the provisions that refer to Article 18.2. So as we said, we have Article 18.2, which is addressed to member states. It has a mandatory nature, and it refers to the contract executions. What is different in all the other provisions referring to Article 18.2? As we said, we will see the content of those in the next slide. Those are Article 56.1, 57.4a, Article 69.3, and 71.1. What is important to say about these provisions is that despite they refer to Article 18.2, they create an obligation on contracting authorities mainly, and they have mainly a voluntary nature. So we should start asking and answering ourselves, can Article 18.2 legal meaning be explained by the content of these provisions? Starting from Article 56.1 on the award of public contract, it says in this that contracting authorities, so not member states, may, so not a mandatory legal nature, Then we have Article 57.4 on exclusion grounds, which says that contracting authorities may, again, exclude or may be required to exclude from participation economic operators in any of the following situations. Then we have Article 69.3 on abnormally low tenders, which says that contracting authorities shall reject the tender where they have established that the tender is abnormally low because it does not comply with applicable obligation referred to in Article 18.2. And lastly, Article 61.1 on subcontracting, which is also non-mandatory, and it applies not to contracting authorities, but on competent national authorities. So the only binding provisions within these four is only Article 69.3 on abnormally low tenders. But what I argue in my thesis is that if we make a closer look to all these provisions, those provisions do not extend in my opinion, the scope of Article 18.2 from the execution of the contract to the procedures and to the same extent to contracting authority and not just to member states. All these provisions contain like the wording applicable obligations referred to in Article 18.2. So my interpretation of it is that Article 18.2 is a principle of EU public procurement, which strangely applies exclusively to the performance of the contract, while all these provisions are merely an invitation to contracting authority to consider environmental aspects during the procedure and not the execution, and that the reference to applicable obligation referred to in Article 18.2 is basically a shortcut to refer to all those obligations without making the provisions too long. So it's a shortcut to refer to applicable obligations in the field of social, environmental, and labor law referred to established by European Union national and international law. That's all. To summarize, Article 18.2 applies only to the performance of the contract, and compliance with applicable obligation must ensure during the execution phase, basically. Verification of compliance during the executions lies on member states or whoever they have designated. And applicable obligations include a wide array of legislation. A direct link to public procurement is not necessary. It is sufficient across applications, like we see with the Posting of Workers Directive that we mentioned before, which was applied in a few cases on public procurement, EU public procurement law. So we are now digging into the analysis of primary law sources, so the environmental principles contained in the treaties. We start with Article 11 on the Treaty on the Functioning of the European Union. This article states that environmental protection requirements must be integrated into the definition and implementation of the Union's policies and activities, in particular with a view to promoting sustainable development. So since it is qualified as a principle and as an objective and is contained in the principle, it is presumed that the application of Article 18 is rather wide. It has been defined by EU constitutional law scholars by a mainstreaming obligation. This means that the meaning of Article 18.1 is stronger, not with reference to environmental law, but to all those branches of law which do not directly have a connection to environmental law, and that to some extent are more detrimental to the environmental field than environmental law itself, which is aimed at protecting it. The importance of Article 18 TFEU, which has been existed for many years in different formulations that we will see soon, is that it can restrict some fundamental freedoms. For example, the freedom, free circulation of goods within the European Union, as we see in some cases like Danish battles. I want now you to look at the provision itself. So the provision says environmental protection requirements, so obligation to protect the environment must be integrated into the definition and implementation of union policies and activities. So requirements must be intended as obligations. Policies and activities, from the interpretation I give to it, includes especially the terminology activities, include the policy making activity by the European Union, and the definition and implementation of these means definition of laws means the lawmaking process itself, and the implementation means the implementation by member states, and of course the scrutiny that the European Union institution make on the implementation of these legislations. So I know that this can be slightly scary, but this table basically, presents Article 11 and its application to Directive 2014-24. So basically, we are now assessing whether the European legislator has introduced environmental protection requirements as required by Article 18 into Directive 2014-24. So what you see here in the top left corner, so Article 130, and also a bit further down, Article 6. When these other formulations of the now Article 11 TFUE were in force, the public procurement directives which were in force at that time contained no environmental protection requirements. Environmental protection requirements were introduced with Directive 2014-24 when Article 18 TFEU was applying within the treaties. And these environmental protection requirements, with reference to what we were talking about before, are basically and exclusively Article 18.2, so the sustainability principle, and Article 69.3 that we were talking about before on abnormally low tenders. As to what concerned the implementation of Article 18 into Directive 2014-24, I randomized the choice of some EU member states from the north, the east, the west, and the south of the European Union to basically to understand randomly whether the only two obligations, so we can say that they might be considered the expression of Article 18 within the European Directive on Procurement, have been applied into national legislation, have been implemented into national legislation. So in Sweden, we have Article 18.2 transposed in a non-mandatory form and Article 69 transposed in mandatory form. Finland, no transposition of Article 18.2 and a transposition in a voluntary form of Article 69.3. Poland transposed both provisions in a mandatory form. Hungary did not transpose 18.2, while 69.3. Italy did not transpose Article 18.2, but transposed in a mandatory form 69.3. And Greece transposed in a mandatory form Article 18.2, but the nature of the provision is slightly controversial, like it needs further further interpretation, which is outside the scope of this presentation, while it not transport Article 69.3. So can Article 18.2 and 69.3 be considered an expression of the obligation stemming from Article 18 TFEU? Well, both Articles 18.2 and 69.3 are not implemented in all jurisdictions. So we can say that the obligations of the European institution to scrutinize the interpretations, the implementation of these provisions has been a bit flawed to some extent. When implemented, indeed, they were not necessarily implemented in the form of an obligation. Article 69 3 applies in general in residual cases, because the formulation of Article 69.3 basically says that contracting authorities, when they consider that an offer is abnormally low, they must reject a tender because of potential compliance with the environmental law obligations. But still, environmentally low tenders is still a residual case, and also the discretion is fully on the contracting authority, which are furtherly not scrutinized by European institutions in the way they apply this obligation. So what is important is that the reason why we analyzed Article 18 TFUE on the so-called environmental integration principle is that non-compliance with Article 18 should lead to annulment of the legislation non-complying with the article. It is true that the annulment should happen within a certain time frame, which is like more than past at the moment with regard to Directive 2014-24. But my suggestion is this: although we have passed this timeline, maybe these findings can suggest that when the Directive 2014-24 will be revised, maybe there is a more proper implementation of Article 18 within the directive. So at the end of my presentation, I would like you to know that these are some of the chapters which I delivered to Professor Schoenmaekers are still in on a draft status, and 2 of them are entirely missing. Although with reference to Chapter 6, there is the mapping exercise of understanding which are the laws under the scope of the thesis and which is the kind of obligations within them has already been done. But yes, I'm still missing 4 months for my thesis, to write my thesis, and maybe also a bit more. So yeah, I would like to conclude saying thank you to all of you for listening to my presentations, and I'm looking forward to hear your question, comments, and doubts regarding my presentation and written output. Thank you very much.
Thank you, Federica, for this. And I will give the floor to Professor Schoenmaekers.
Yes, good morning, everyone. Good morning, Federica. I have very much enjoyed reading the draft of the first 5 chapters of your PhD dissertation, and it really discusses a very important topic, namely the link between public procurement and climate change mitigation. And I always think you must be very courageous to start a project like this. First of all, because this is not only about procurement, also about environmental law. So that means that you need to study many different legal instruments. And secondly, because this topic is high on the agenda of the European Union. So that means that it is constantly progressing and you do not know in advance what you get yourself into. So for these reasons, I would already like to praise your work so far, and I will also provide you with some more details on the aspects that I really appreciated. So let me start by these elements. I really think that you provide a very, very well-structured chronological overview of the involvement of environmental or green considerations in EU law, procurement law in particular, and also the case law of the Court of Justice of the European Union. And you make a clear distinction in this regard between the era pre and post the European Green Deal, which makes your line of reasoning easy to follow. It is very interesting to see that strategic procurement is actually already very old. while the practice was only codified at a much later stage and is to this day still not widely exploited. So you compellingly state that excluding public procurement from environmental policies appears illogical, incoherent, and your thesis contains a detailed reflection on these issues. And this clear approach is noticeable in many different parts. For example, when you explain the difference between climate change mitigation and climate change adaptation, and when you indicate the legal sources that exist for every objective. Furthermore, you describe very clearly how the European Union is in the course of changing its approach from only dictating member states how to buy to increasingly dictating what to buy as well. And you show that European public procurement rules are now incorporated into a new corpus of secondary legislation, often environmental laws, which widens the scope of procurement. Indeed, whereas previously the focus was on regulating the conduct of the procurement procedures to ensure fair competition, this new secondary legislation includes obligations to purchase specific products, to achieve specific targets, or to exclude non-compliant entities from procurement procedures. And in this regard, you pinpoint that public procurement across the European Union is greener than it used to be, but is still not green, and that the legal framework has, as I also mentioned in the beginning, become highly fragmented and complex. So what is certainly an added value of your work is that you do not only focus on what is prescribed by the law, but that you also aim to focus on the legal consequences of non-compliance. And that is, I think, a very interesting aspect of which I would love to read more in the future. And finally, because the praise has to stop somewhere, I also want to mention that I appreciate your horizontal approach, as you do not only focus on specific procurement articles, but also on the more general provisions and treaty articles, such as you also discussed today, Article 11, but also Article 7 of the Treaty of the Functioning of the European Union, Article 11 stipulating that environmental protection requirements must indeed be integrated into the definition and implementation of the Union's policies and activities, in particular with a view to promoting sustainable development. And I believe that you rightfully interpret this as meaning that it creates an obligation for the European Commission to incorporate environmental requirements into the proposals of new legislative acts. But as I was asked to provide you with some more critical feedback as well, I will provide you now with my comments, which you should of course not take as a criticism, but as elements that may deserve some further thought in the future. Number one, my main comment is that you focus a lot on describing the law as it is. And I perfectly understand this, as your central research question is, how does European public procurement law address climate change mitigation? And while this is for sure an interesting question, it entails that your analysis and your answer is going to be rather descriptive in nature. And in your thesis, you already explain that you want to make an analysis of the law for what it is. And that is, of course, certainly possible. But nevertheless, the societal relevance of your work would be so much increased if you would also include a future outlook. And I noticed that in the final chapter that you still need to write, but in your introduction, you mentioned that you want to provide practical recommendations, which are obviously recommendations for the future. But nevertheless, your research question does not seem to have any future perspective in mind. So I was wondering whether that is not standing in the way of making actual practical recommendations for the future at the end, or at least whether it is not standing in the way of making the most of your work. Number two, the topic of your thesis is public procurement as a tool for climate change mitigation. And in your work, you indicate that climate should not be viewed separately from environmental protection, but rather as one of its components. But throughout your thesis, this distinction is somewhat blurry at times. For example, the case law that you discuss is often not specifically focused on climate change, but on the environment in general. And my advice would hence be to pay a bit more attention to discussing the difference between these two concepts and to make this more concrete, because the difference is not really explained anywhere in your work so far. And I would argue that the majority of your writing is also relevant within the broader framework of environmental law. Number 3, you rightfully mentioned that the European Union has the ability to promulgate regulations that shape the global business environment, leading to a notable Europeanization of many important aspects of global commerce. And I wonder myself whether and to what extent environmental concerns and concerns related to climate change are or are going to be misused by contracting authorities to push economic operators from other municipalities, from other provinces, from other countries out of the market for economic reasons. So how valid is this concern according to you? And are there any cases that demonstrate that this has already happened? Because I can imagine that if contracting authorities focus, for example, on transportation cost in the award criteria, with the idea to reduce CO2 emissions, companies from abroad may be artificially excluded. So in situations like this, how can one check whether such an exclusion is artificial or whether it is actually justified for environmental concerns? So how does such check actually work? And even more, can this ever be objectively verified? And in this regard, I particularly want to refer to the case of the European Court of Justice, EVN Wienstrom, which you also discuss, of 2003, which hence dates from prior to the 2004 and 2014 directives. Because in this case, a contracting authority referred to environmental performance as part of the award criteria, and the court was asked to clarify the conditions under which such a criterion is permissible under EU law. And in your thesis, you mention that the court ruled that verification, and I stress the word verification, of the accuracy of information was not required, and that the fact that the absence of evaluations affect the actual and practical attainment of the goal that criteria aimed to achieve, but did not constitute a violation of EU law. So there's no verification or no proof or no idea of how the verification, the evaluation actually functions, but nevertheless, it was concluded that there was no violation of EU law. And that makes me really wonder whether this can lead to this artificial exclusion, to abuse, but also whether you think that if this case would be before the court today, whether the outcome would be more or less the same. Because on the one hand, the current directive now refers, for example, to life cycling costing as one method to determine the most economically advantageous tender. But on the other hand, I don't know if we can be sure to what extent such method is actually applied, and let alone being applied correctly. So more generally, I wonder whether we are in a desperate need of more monitoring by the EU. Just like we, for example, do not have an EU whitelist with companies or blacklist, but I mean a whole EU-wide list, so for the whole EU, with companies that have been excluded by public authorities in the member states. We don't have a full list like that. EU law also does make it clear how this should be monitored and whether member states ensure that economic operators comply with their environmental obligations under Article 18. So what is your take on this? I'm really happy or curious to know more about that. Number 4, you discuss and refer to several pieces of secondary legislation that have recently been introduced in the field of environmental law. And in several of these pieces of legislation, public procurement is referred to. Why do you think that it takes so long before the European Commission starts really working on a new proposal for a directive on the award of public contracts, in which it takes all these other rules on environmental issues into account? We normally have a new set of directives every 10 years, and there's so much work already done. But nevertheless, when it comes to procurement in particular, it feels like we are really lagging behind a bit at this moment. So do you think there are specific reasons for that at this moment? And then number 5, of course, I cannot miss to discuss Article 18, paragraph 2 of the directive, because you really pay a lot of attention to that. And I just repeat for everyone what this article stipulates. It states, member states shall take appropriate measures to ensure that in the performance of public contracts, economic operators comply with applicable obligations in the fields of environmental law established by EU law, national law, etc. So as I said, and as we could all hear, you really discussed this article in great detail. And firstly, in this regard, I wonder, do you think that this article adds anything or has any use at all? It is, as you refer to, a real principle of public procurement law. So then you would say it is very important. But on the other hand, it only confirms what one already knows, namely that economic operators have to comply with the law. And that is something that is very normal, very straightforward. They have to comply with other legislative norms, environmental law, social law, labor law. So does it really add anything to the table? And secondly, you state that this article is only applicable to the performance phase. That is true. It really mentions this literally. I just repeat it maybe for everyone. Member states shall take appropriate measures to ensure that in the performance of public contracts, economic operators comply with environmental law and so forth. And I wonder, do you have any views on why this article was worded like this, specifically then if you compare it with the recital? So could it simply be because the directive does not foresee in mandatory sustainable procurement, and that for that reason there's no need to really say that it has to be worded in a different way or in a broader way? Because coming back again to this recital 40, where it is indicated that control of the observance of environmental law provisions should be performed in the relevant stages of the procurement procedure, so also the selection phase, the award phase as well. Still, it is still about controlling the respect for other legal provisions that already exist. So perhaps you could argue, but I don't know, that Article 18 does not add any obligation for economic operators because these obligations are included in other legislation. So should it really deserve so much attention, this article? So I'm happy if you would say yes, that's no problem. But I think it might be useful if you could give some more attention to this particular issue in your thesis. Then number 6, you mention in the written work, but also today in the oral presentation, that contract performance is outside the scope of the directive. However, I think it is not really nuanced how you mention this, because the directive does contain a full title exactly on contract performance, which contains, for example, rules on the modification of contracts, on subcontracting, on the termination of contracts, on the conditions for the performance of contracts. So I do not really agree if you argue that the directive does not deal with contract performance, or at least if you say it so bluntly without refining that. And you also discussed the pollution-based principle, and you rightfully say this is not part of procurement law as such, because it is referred to in Article 191 of the Treaty on the Functioning of the European Union, which is an article in the framework of the European Union's environmental policy. So this pollution-based principle is a principle stemming from tort law to compensate for the damage that one has caused. And damage in public procurement generally occurs in the contract performance phase. So do you think it should be added in the future as a provision in the directive? And more generally, whether the contract performance phase should be more heavily regulated in the future in the directive? For example, by adding this polluter-pays principle. Number 7, on page 72, you refer to Professor Sanchez-Grals, indicating that an instrumental use of public procurement to achieve socio-political aims differs from and often contradicts its basic goals, such as competition. That being said, in the European Union, free competition, so when we discuss competition law in general, is also reconciled with other interests, such as environmental concerns, regional development, R&D, etc. In addition, competition law allows for important social corrections, such as is the case for services of general economic interest to combat social exclusion. So the Commission also advocates an instrumental use of public procurement, which you also refer to. So what is your view, I wonder, on the increasing instrumentalization of law in general? So is that something that we should want? Is it not a little bit a way to actually evade the competences or to say more than is actually meant for when a legislative norm was created? So that is something that you could perhaps add from a more general perspective. Number 8, you rightfully refer to the tension between economic goals and environmental goals in procurement processes. And you mentioned that the Court of Justice should be inclined to interpret the law in the direction of the most urgent objective to be achieved without omitting the others. So how should be determined what is most urgent? Is that not a political decision? So is the court well placed to take such a decision at this moment? And how do you assess the principle of subsidiarity in this regard? Number 9, you mentioned that the Court of Justice has indicated that competition is not artificially narrowed down if the price on which the contracting authority does not exceed the estimated value of the contract. But how can contracting authorities make a meaningful estimation? They are no experts. There's no obligation to carry out a preliminary market consultation. So it would be nice if you could focus a little bit more about this artificially narrowing down of competition. It was also mentioned in one of my comments earlier. So it is an aspect that you really focus on in your thesis. And I think that because it comes back at several moments, it deserves a little bit more of attention. Number 10. You mentioned that the directive does not implement or apply Article 11 of the Treaty on the Functioning of the European Union satisfactorily, as Article 11 contains an obligation to integrate environmental protection requirements. As you rightfully mentioned, there is indeed no obligation to buy green at this moment, and the directive only contains an obligation for member states to take appropriate measures to ensure that in the performance of public contracts, economic operators comply with applicable obligations in the fields of environmental law, as well as an obligation to exclude abnormally low tenders due to disrespect for environmental law criteria. So that is this Article 69 and 18 that you also referred to before. And you mentioned that these obligations, so the obligation in Article 18, which only refers to the contract performance phase, and the obligation in Article 69, which is only about abnormally low tenders, that these obligations are so small in scope that Article 11 is actually not respected, because due to the small scope, you're not actually respecting or taking into account environmental issues. But Article 11 does not dictate how far one should go. It only refers to the fact that one should take things into account, that there's an obligation, but there's no indication about how far this obligation actually reaches. So can you please also provide some more views in this regard? Number 11, and don't worry, I'm not going to take too much of your time, but I also wanted to address that there are many voices nowadays for mandatory sustainable procurement. And also in one of the pictures that you show today, you referred to the book written by Professor Caranta and Professor Janssen, that is specifically about this very topic, mandatory sustainable requirements in EU public procurement law. So the title of your thesis is Public Procurement as a Tool for Climate Change Mitigation. So will your book also conclude that we will need more mandatory procurement? And if that is the conclusion, can you also indicate to what extent your book will then add to the findings of Professor Caranta and Professor Janssen and all the authors that actually wrote a chapter in that book? And number 12, and that is the final point, I think that chapter 6, which you have not yet written, you have thought about it, but you have not yet written it in detail, but that is going to be the most important chapter, as you will discuss there secondary law on low emissions public procurement. And I really think that you still have quite some work in this regard to ensure that the thesis does not give the reader the feeling that its core, its main part, provides only a chronological overview on green procurement. I know you do much more, but it is, as I said also in my first point, rather descriptive. And I still wonder what you will add in this regard. As in this book that I just referred to, for example, they also contain chapters, that book also contains chapters on secondary law, such as the Clean Vehicles Directive. And if I understood you correctly, that is also something that you want to discuss in this chapter 6. So for me, you still need to show that you are taking things to the next level by also critically analyzing the context of this legislation and its relevance for public procurement. At this moment, this is not in the thesis yet, which is of course no problem as you have not yet finished your work, but I really want to encourage you to invest time to describe this in a detailed manner and to also include a critical analysis of this secondary legislation and to provide really crucial comments yourself that can help the European legislator to take wise decisions when it comes to regulating procurement for the future. So I'm looking very much forward to your views on some of those issues that I just highlighted today. And I thank you already very much.
Thank you, Sarah. We will give now opportunity to Federica to respond to some of the comments and questions. And Federica, you also should feel free to ask follow-up questions to Professor Schoenmaekers if there is a need for any clarification. So the floor is Federica, yours. We cannot hear you from whatever reason. Nope. You're not muted on the screen. Yep, something happened, I think maybe with the headphones.
Can you hear me?
Yes.
Okay. So I would kindly ask to Sarah for some questions for her points to maybe pinpoint a keyword for me to remember all the things, because I couldn't take notes of all the questions, to be honest. So if we can start maybe from point 1.
So point 1 was about, yeah, that you are not really discussing future perspectives. You are talking about the law as it is, but on the other hand, you say that you will provide recommendations. Recommendations are normally things for the future.
Yeah.
And I was confused about that. So maybe you can start by discussing that.
So, Sarah, thank you for the comment. I totally understand that there is a misalignment between what the thesis says it's going to do in a more extensive way in the introductory chapter, and maybe the structure of the thesis itself might not properly represent what I say I would do. I honestly thought that a section on future perspective is basically sort of mandatory for each thesis, besides the adoption of the lege ferenda approach. But I will for sure follow your advice to explain properly in the introduction why I want to recommend. I also remember that you mentioned that the scope, like the relevance of the thesis would be even more enhanced if I would consider future suggestions for the future for how the law should be, basically. And the reason why I didn't adopt this approach from the very beginning is that the amount of legislation which I'm taking into account is extensive, and they are pretty new. So of course, if I would have understood that the findings coming from the lege lata analysis of all this legislation would not lead to findings or relevant findings, I would for sure say how those provisions could be changed in order to make a proper account of environmental protection. But being those instruments rather new, I didn't even want to maybe suggest changes to the legislation, which in case are going to occur in many, many years, because the legislation subject to Chapter 6 are actually rather new, so adopted within the last 2 or 3 years, and some of them are still proposal. In that case, I am not sure that they will look at my thesis in time to consider I'm not sure that they will look at my thesis at all to consider changes. So this is my answer to this point.
I think you should not worry about whether they are going to consider your thesis. I think,
and not on time, at least.
Yeah, I just wanted to add, I understand that, but if you are going to describe the secondary legislation in your Chapter 6, that for me personally, yeah, but of course, I'm not making the final call. It would be nice if you could do more than just describing the legislation, because I think for a PhD thesis, you need to go to the next level, and just a description of things is, yeah, it is rather basic in that regard. Would you like me to go over all the points?
Yeah, I would just like to reply on this point, because I think that this aspect of the secondary legislation was touched upon in another point as well. I understand that the current outlook might seem rather descriptive on this, but my plan is not to analyze what the legislation says. I am quite sure from legislation that I've already analyzed and legislation that I just looked at, that the obligation they create for public procurement procedures, so the interaction that they have sometimes with public procurement in general, or Directive 2014-24, if it is mentioned, is not straightforward. In the case, for example, of the EU deforestation regulation, I could have simply described what is the obligation that it creates for public procurement, but with a colleague, we wrote a paper where we analyze what are the implications of the obligation created by the deforestation-free regulation. And basically it is, and it touches upon one of the interesting points that you were mentioning, that the deforestation regulation creates a debarment system union-wide. I don't know if also the analysis of what are the implications of creating an EU-wide debarment system, I don't know if this is also considered by you rather descriptive or not. Because for the moment, I thought that reaching that kind of depth, so analyzing the implications and finding new trends in the public procurement can be considered enough. But I think it's very important at this stage, and I really value what you will say about it, to understand what is descriptive, what is not, what can be considered like an in-depth analysis, and what is not.
Yeah, if I would respond, I would say, and indeed, the deforestation regulation does foresee in such a system. I think that what you could then do is to discuss whether such a system should be there for any violation of environmental or climate change law, and not only deforestation. So should Article 57 of the exclusion grounds in the Public Procurement Directive, should that also get an addition saying that, and there will be a white list. So now the union white list is going to be only for deforestation. That's really nice, but why is it not? Or would it be better if in the general directive we would also have such something like that? So that is something you could look into.
Thank you.
The second point was just, you don't have to go into that now, but was a request if you could focus a little bit more on the description of the difference between climate and environment, because you assume that the reader knows, but I don't think that every reader will know this. So you mentioned that the environment is broader than climate, but that's it. So that is just something that you can easily do. And then the other thing was whether you think that there is going to be many cases of misuse by adding environmental issues, because of course you can say this is good for the environment, and you can of course narrow down the market. Competition is always narrowed. If you buy office chairs, you don't buy computers, so only a few competitors can participate. But if you are going to look at transportation costs, CO2 reduction, that also happens. So in essence, that is not a problem. But how do we know whether competition is not artificially narrowed down? So this artificial element, which is of crucial importance, how is this going to be verified? Can that be verified at all? It's a difficult question, I think, but I don't know if you have any views on that.
Well, this is the most difficult question of all. I think I asked this question like a couple of years ago when I was in a conference, conference to a Danish legal scholar here in Denmark. And to be honest, I don't have an answer to this. Like, I think that verifying whether competition is artificially narrow is as complex as to verify whether violations of human rights or environmental obligations happened along all the supply chain. It requires a concerted effort, and also it asks the EU institution or member states or competent authorities to establish themselves, I assume, a system of verification of whether these have artificially narrowed. I see it, and I'm not saying that is necessarily doable, but when I imagined it, I see it a bit of basically a declaration of demonstrating what they need to, what contracting authority want, and if it is particularly sustainable, so reducing the competition a lot. They, for example, may demonstrate that the supplier is not a supplier they have had the previous relationship with, that they don't know anybody within the company. This is how I see it. But to be honest, I haven't focused so much on this aspect.
I think that if you would include something like this, you don't have to, but if that would already add again to having more an analysis, a critical analysis than a descriptive reflection. So yeah. And one of the other questions was what you think about what I said. Is Article 18, paragraph 2 really so important? Does it actually add anything? Because it just says economic operators have to respect environmental law, but that is already a given because that follows from environmental law. So what does it bring to the table?
I totally agree with you that Article 18.2, for how it is formulated, adds basically nothing. And it's also the reason why I don't believe it can be considered a proper implementation of Article 18.2 if interpreted by a person which would advocate for a more inclusion of environmental considerations and more in-depth consideration of environmental considerations in the directive. I think that what you stressed is a point I totally agree with. So economic operators, for how 18.2 is formulated, are not asked to do more than what European law actually asks from them. I totally agree. I think that the layer that Article 18.2 adds on this is to create an obligation for member states or for whoever, like depends on how you interpret it, contracting authorities or competent authorities to verify whether in the public procurement procedure and procedure and execution of the contract, to give them the responsibility to comply, to verify whether they comply. And I think that this is a extremely big responsibility for contracting authorities, right? Especially because now we are witnessing the rise of also laws from the European Commission, which, as I mentioned before, require verification with the very, very, very far stages of the supply chain of certain products. So I think that I also mentioned it perhaps not very clearly. I agree with you that Article 18.2 this way adds nothing, because it basically asks to economic operators to comply with already applicable obligation. But what asks to member states is not to be given for granted. But I also think that the Commission, despite creating this like problematic provision, did not foresee any mechanism to verify whether member states verify themselves if economic operators comply. So I think this is the problem. There is it can have a bigger potential, which is wasted because of lack of verifications. But yeah.
And I agree with you because indeed member states have to comply with EU law, but member states have no obligation to ensure that national law is going to be respected. There's no authority or no law saying that you have to prosecute someone if that person or company commits a crime, an environmental crime. It's always left at the discretion of the member states, so they don't have to necessarily focus or prosecute violations of national law, unless, of course, that would be an implementation of EU law and so on. So that is indeed an added value of this article. Now, they even are obliged to ensure that national law provisions are going to be respected. Yeah, I agree with you. And the next issue was whether you think that this chapter on contract performance conditions in the directive should be extended. You stated that it is actually not really about, it's not really in the directive, but it is nevertheless there. But it is there. Do you think that it should be added with other articles, sorry, should be added to it? For example, the polluter pays principle.
So I really appreciated your point on the polluter pays principle because it gives me a perspective that I didn't have the possibility to dig into yet. I agree with you that there are articles of the directive which mention the execution of the contract, and actually it was my mistake not to be scrupulous enough to mention it during these rehearsals of the presentation. Nonetheless, what I maybe need to specify more with the aid of proper resources is that the European Union does not extensively regulate the post-award phase. So although there might be a modification of the contract, which could lead to annulment, and maybe, or if it is minor or not, but if it is a major modification of the contract during the execution, that could lead to the start of a new procedure. That's what I mean. Like, the contract is not scrutinized. It's not like overviewed by the Commission, by the court. It's basically a matter of the economic operator and the contracting authority themselves. That is what I meant.
And would you think it should be added, so that more articles should be added in that chapter, or not?
The analysis of the articles on the execution?
Yes.
I think that for the moment I would leave it aside. But in case I find out that maybe the scope of the thesis is not maybe relevant enough, or if the findings are not what I aim to, perhaps I can analyze that more in depth. But I would say that an in-depth analysis in that regard requires a kind of deep knowledge in contract law, which I lack. And I don't want to add, with my lack of expertise in contract law, something that is maybe like poorly analyzed just for the sake of completeness. Perhaps I can add at the beginning, in the introductory chapter, that the specification that these aspects would be left out because I only focus on the procedure. Okay, yeah. And then I also had a question about reconciling environmental objectives with competition objectives, because you stated that if that happens, then it is up to the Court of Justice to actually find out what is the most urgent objective. And I was wondering, how can you determine that? I know it is a classic question. It is actually free movement law. There's a justification. The Court of Justice can always say that something is a justification, but still, in this area, the question is this not really more a political decision then? Because there is no obligation to procure green, and we are moving slowly towards that direction. And is the court then not more easily stepping in the shoes of the legislator when it is confronted with cases like this? Yeah, I think it is a political decision, and I think the political decision has already been taken. For me, it's pretty evident that the European Union is going in that direction, and that also national courts are going in that direction. And we are witnessing a lot of cases of climate change litigation, which are kind of groundbreaking and not necessarily widely shared in their outcomes. So I think the political decision is already there, and we showed it through also the EU climate law and the nature restoration law. So despite years of debate about the adoption of a law, now we have a majority with a law with a couple of laws that will change the rules of the game. The problem is always, of course, the implementation. I think that the way economic goals and environmental goals are to be balanced is something that the court in the case law did in a rather unexpected way. So what my analysis of the case law, also outside the scope of the thesis, so outside what you read, what I think about this, the landscape of environmental case law, is that it is not super clear how the court applied the proportionality principle in certain cases. It seems sometimes that the same case could have been decided to the detriment of environmental goals, or to the detriment of the freedom of movements. So I think that the reference in my methodology to an interpretation of the laws which can favor the most urgent goal in the area where we are interpreting the law is a sort of, allow me to use this word, escamotage, to avoid the never-ending debate with the proportionality principle, because I think that at the end is the scrutiny of the court. What I think is that there are for sure good elements to think that the court will interpret in a way that is more favorable to the environment than it ever did before. Yeah. This is what I think. With the adoption of the climate law and with the adoption of the restoration law, I think that the landscape is changing and that the court will recognize. But this is, of course, my humble opinion and
and I think that you often have quite some cases in which the Court of Justice actually leaves it to the national judge to take the decision on the proportionality principle. And you could question, does that happen more in areas that are a coordinated competence, like culture, for example, because that is more a policy domain that is mainly left within member states? And does it happen less with the environment, which is a shared competence between the Union and the member states? So, yeah, it is really interesting to see whether the Court of Justice is more lenient in that regard or not, and how it is developing. But you do describe several cases in this matter on page 73, for example. So, it is really interesting to look at that. Yes. And maybe finally we could also discuss that element of Article 11, because Article 11 states that member states should take appropriate measures to ensure that, let me check, I don't know by heart, but Article 11 of the treaty actually saying that the environmental concerns have to be taken into account by the Union when it is making new legislation. And I was wondering, this article is still rather vague. It is an obligation, but on the other hand, it doesn't say how much or how wide the scope of these environmental concerns that should be taken into account actually is. Do you also see there a role for the proportionality principle, or how do you think we should assess this? I saw that you also looked at one piece of secondary legislation to show how the European legislator was doing this. But of course, we would like to know this in a more broader, more consistent way. So what do you think? Is proportionality playing a role there or not?
So I think in this point you refer also to the point that Article 18 of the treaty creates an obligation, but it doesn't say how much we need to go. I think that also this is a matter of interpretation according to the times that we are living. I don't want to give a flawed answer to this, but and it's also a matter of like legal school you come from, right? A very narrow interpretation of the article says, it creates an obligation to introduce environmental requirements. Do we have environmental requirements in Directive 2014-24? Yes, then Article 18 is applied. I don't think that this is the way we should go about it. I think that the way we should look at it, it's also it should also be intersected with what the climate law says. So if the European Union law should be taken is to be taken seriously, as we are thinking here, I think that establishing an overarching objective of climate neutrality without saying how procedurally we're going to get there implies that in the meanwhile, the law must be, the instruments that we already have in the law must be interpreted in a way that resonate with those obligations. So Article 11 might not say how far we should go about it, because the legislation should says how far we go about the obligation. And the way the legislation should say how we go about it, one method could be really to assess whether the mainstreaming obligation contained in the climate law are properly implemented, because also Article 6 of the European Climate Act, the European Climate Law, says that the Commission is have an obligation to review laws and whether they comply with the obligation of climate neutrality and the greenhouse gas emission reductions by 2030 and 2050. So my analysis would also deal with how Article 11 relates to the climate law. What is actually the scope of the real scope of the climate law? Because I think like the whole thesis can largely revolves around that.
Yeah. And let's assume that indeed Article 11 would be violated because the Public Procurement Directive is not really taking environmental aspects sufficiently into account. Let's assume that would be the case. What can be done about that? Because if you look at Article 263 of the Treaty on the Functioning of the European Union, you see that you can sue the European institutions if they did something wrong when, for example, creating legislation. But who can sue the European institutions? Only the European institutions themselves. They are the applicants, so the Commission is not going to do it, the Parliament not, the Council not. And for individuals and legal persons to do it, they need to have a direct and individual concern, and they will never have that because it is a law, a directive that is applicable to everyone. So what can be done then actually against this? Could the court ever say, or how would it happen? Could this ever come in front of the Court of Justice?
I think that there are two ways to go about it. The first one is whether a recently adopted legislation is violating Article 11. According to EU law, if there is a violation of Article 11, we can still record to the annulment procedure for that law. The second way to go about it is that, as you said, we are now in a moment in which we cannot claim anymore that since Directive 2014-24 does not comply with Article 11 can be annulled. But it's still, the interpretation I give says that it is not compliant with Article 11. So at the moment, there is nothing we can say. That's why I can suggest that in the next draft of the regulation of the directive, there should be a proper implementation of Article 11. I think that although is my reasoning is comes also from other areas of law. It is true that either EU institutions or a class action, for example, can be used to claim that a legislation is flawed and does not comply with the EU treaties. But I think it's not too far to think that it can happen. I think that it has happened that laws in the member states, which were not theoretically at the first look from a more conservative look, would not apply to would have no direct concern for the citizens, for private parties, then they were used as climate law litigation cases because, I don't know, the Klimasenioren in Switzerland, they couldn't breathe a clean air, and this may cause like lung cancer to them. I think that we are in an era where these connections, for the good or for the bad, they are made despite not clear at a first look, and that also the courts are endorsing this.
Yeah, so from a procedural point of view, when you talk about annulment and validity, you would see that then in the framework of the preliminary question under Article 267 of the treaty, I assume. I think maybe because you say, I'm also going to discuss more the the procedural elements and what can be done about possible violations, that you should add still then more about what kind of procedure, how does it take place, is it at the national court, the European court, on the basis of which article? So that is something I think that should be further developed then.
Thank you.
And maybe the final point, I asked as final question before, what is your work now adding? And I showed this book edited by Roberto Quaranta and Willem Jansen, and I must admit I didn't have even the time to read it yet, or not, at least not every chapter. So it is just a very broad, vague question. I cannot really say you did this, they did that, they did that. But just from a general point of view, can you, for everyone also present here today, maybe in 2 or 3 sentences say, chuck, 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 this is what my work is now adding?
Yeah. So with the specific regards to the book by Willem and Roberto, I think that only a few chapters deal with the specific secondary legislation. And that is why, like, I extended this, and there are also new legislation compared to when the book was drafted like 2 years ago that I will analyze. I think that the other way my thesis is novel is because there are environmental principles contained in the treaties have not been analyzed the directive has not been analyzed yet in light of those principles. And although it can be, to some, it may seem quite a stretched interpretation to think that all those principles apply. As I said before, I think it is relevant to do it at this stage. I think that also so far, even if I'm not yet at a far stage of my thesis draft, also what I say on Article 11 is something that, although Article 11 and Directive 2014-24 have already been interpreted jointly, I think that I'm adding something new to what the existing literature has.
Okay.
Yeah, I think, like, my thesis also comes in a very important stage of European Union law and European public procurement law. So I think that the reason why it can seem that, for example, you mentioned the aspect of environmental and climate law, which is perhaps needs to be explained more clearly, is that if I look at climate mitigation law per se, how they are defined by climate mitigation law scholars, those legislation with no doubt apply, apply not at all to subjects to a public procurement procedure. So they must be outside the scope of my thesis, unfortunately. Maybe the effort sharing regulation can be subject to the analysis within this thesis. But for example, the other legislation in climate mitigation law, absolutely not. So this led me to the point in which the only legislation it was worth analyzing was all those legislation directly referring to procurement. I could not foresee on the way that a book was coming, but I still think that something good and new can be added, and that my book will add a comprehensive analysis of all this legislation, and will reduce the scope of Roberto and Jansen book.
Okay, Federica, thank you very much. I have no further questions or remarks. It was very nice discussing this with you. If you want, I can provide you with my comments in writing, so I can email them to you if you want. And then I think I give the floor back to Professor Andhov.
Thank you so much, Sarah, for such a thorough revision and comments. Very much appreciate that, and Federica's interventions and providing further clarification. I think that has been so far extremely beneficial to the thesis, and I hope that this all will help out Federica to further improve the draft. I think that what I will suggest right now is that I will open the floor to our participants. We have all of us are 11 participants in the room. So if there's anyone who has a question or comment, this would be right now the time to do so. Or raise your hand or write in the chat or just unmute yourself. Do we have any questions from the floor? Okay, Professor Khan, please.
Yes, thank you very much, Marta. Thank you very much, Professor, for your great feedback. First of all, I would like to congratulate Federica on your thesis. It's very interesting. It's also very complex. I would like to come back to the aspect which was in this point 6 of Professor related to the performance. So my observation is that to have the whole picture, I think performance phase is crucial here. First, because when we see the thoughts on the public procurement generally, we see that if we want to have the whole picture, the award stage is not enough. The performance phase, also from the practical perspective, is very important. So I think it will be very worthy to add also some of the comments related to this phase. Also, the second thing is that in Article 18.2, there is the word performance, which in my opinion requires the deeper analysis of this stage of public procurement. If you decide not to do it, I think what will be worthy is first, during your presentation, we saw the table in which you divided the articles related to award phase and execution phase. And there in this table, you have Article 71 in the place of award phase, which I think should be corrected because this is the performance stage. So this is first. Then you also used the words performance or execution. I think it can be a little bit confusing. I would rather suggest to take one of them as a main and use during the whole thesis. Then the third thing is also during the contract performance, we have the Article 70, which I think is also very much relevant here, the conditions for contract performance, where you have the environmental aspects directly included into this article. So I think it will be also very important to consider if there should be some aspects. Of course, if you decide to go a little bit deeper into this topic, I think also the modification because of some environmental aspects will be also very much relevant. They were also presented during your panel in Birmingham by Professor Piotr Bogdanowicz. So generally, I think performance phase here is also crucial. When it comes to my question, there are a lot of information about interpretation. Article 11, also, of course, Article 18.2 of Directive. So will you address in your thesis how you understand the interpretation methods if you are using the literal, maybe systematic, theological method of interpretation? Because you said some of the today that there is a narrow interpretation, that interpretation of this article. So will you also address this problem in one of the point? I think not the sub chapter, but generally in one of the point of your thesis. And the last thing, I also fully agree with the point 1 addressed by Professor. So I think it's very worthy to add this de lege ferenda or de lege ferenda points. And if you do this, I think you also need to address this in the point related to methodology, because right now we've heard that you are only basing on de lege lata point. So I think it would be very worthy to say, okay, I would like also to propose this de lege ferenda proposals for the future. Yeah, so I think only one question is the second one related to the interpretation methods.
Thank you, Michał, for your points. I think it's very on point what you said about this. The approach that I say that I'm utilizing in the thesis is a teleological approach. I think that you are right that I should be more specific in the way I go about it. I of course use literal interpretation. I think it's a mix of all these things. Like at the end, the literal interpretation the instrument of literal interpretation can be useful and can give answer until a certain points, right? So I think I supplemented it with this teleological way of interpreting, and for the research I did, basically you can further interpret teleologically by these by also utilizing this theory for which you favor in the interpretation the objective which is more at risk in the historical moment when you are interpreting, which it was something we were talking about it with Sarah. But thank you for all the other comments as well.
Wonderful. Thank you so much for that. Do we have anyone else that has any questions or comments to Federica's presentation or her thesis? Okay, then I think without further ado, we can formally conclude the pre-evaluation. I, from my perspective, would want to once more warmly thank both Federica for the preparation for today and the presentation. I think that Federica, you can definitely feel proud of yourself on how you presented your thesis. And warm thank you to Professor Schoenmaekers for dedicating her valuable time and the detailed feedback provided. We are extremely grateful for your help in this regard, and have no doubt that it would contribute to further improving the quality of the thesis while Federica enters that last moment of time of finalizing the thesis. So thank you so much. I thank you also to everyone who joined us on this early, was it Wednesday, on this early Wednesday morning. We appreciate you sharing your morning with us. Have a wonderful day. And that's about it for today.
Thank you.
Thank you, everyone.
Thank you
and
so
thank
much.
you, especially Sarah and Marta.
You're welcome.
Wonderful.
Have a
Very
nice
much.
day.
You
Take
too.
care.
Bye.
Bye-bye.